market we need to get to. Thank you for working so collaboratively on this hearing. Director Vidal, I think we certainly agree that the current framework for determining which inventions are eligible for patent protection is just not working. We see remarkable developments in artificial intelligence and medical diagnostics. What changes, in your view, to the patentability framework would provide greater certainty to inventors around what can be eligible for patent protection?
In my view, and a lot of this was articulated in the TROP and interactive wearables case, we need more certainty and clarity. Right now, the biggest issue is that. Beyond that, certainly if there are categories of inventions like patent diagnostics, if those were singled out as areas that could be patentable, certainly that would also provide additional clarity.
I was struck the Federal Circuit held that the guidance that you offered was not binding on courts. I think an obvious implication of that is that Congress has to step in. Am I wrong? Can the USPTO take further steps to tackle patent eligibility that I'm missing?
Changing the guidance, I don't believe, would be of any help when it comes to tackling it at a higher level. Certainly that would control the patents we issue, but what happens with them when they leave our doorstep is beyond our control. So beyond that, we are engaged with the court system to try and make positive change there. Be more than happy to work with you and Senator Tillis's office on the proposals that you have out there and provide technical assistance on that.
Well, we invested a huge amount of time in trying to sort of square the circle of patent eligibility, and we intend to take another strong run at it and would be grateful for your close cooperation. The areas that are currently outside the ambit of patent protection have become more and more critical to our country, our competitiveness, our economy, and I'm afraid we are creating a critical vulnerability for our competitiveness. Let me talk about counterfeit goods for a moment, if I can. What's the Patent and Trademark Office doing to address the rapid proliferation of counterfeit goods, especially those marketed online, and what do you think Congress could do to address the sale of counterfeit goods online?
Starting with the second question, anything that Congress could do to create laws and create rules that would cut down on counterfeiting would be much welcomed. I'm very concerned about the effect that counterfeit goods not only have on our economy, same thing with pirated goods, have on our economy, but also, as you mentioned, on the health and safety of our people. In terms of what the USPTO is doing, you mentioned the Go for Real campaign. That's been a real successful campaign. We've also created online games that have been downloaded by 17,000 educators to educate them about counterfeit goods. We teach children through our Camp Invention, 280,000 children last year, about counterfeit goods and the dangers, and help teach them the reason why they want us to respect IP, because they have great ideas that they want respected. Beyond that, we work both domestically and internationally on policy. And we're going above and beyond when it comes to counterfeit goods. I made that clear as soon as I came on board that was something that I wanted to tackle. We just issued a Federal Register notice trying to find out from our stakeholders future strategies when it comes to anti-counterfeiting and anti-piracy and what more the USPTO and U.S. government can do to help. We work with law enforcement agencies. We work with other countries to help set up infrastructures and laws within their countries. Even as I sit here today, we have over 50 judges from the Indo-Pacific region over at the USPTO engaged in dialogue with a judge on the federal circuit and other judges in the United States on issues like this so that we can have a common ethos when it comes to counterfeit goods and the importance of IP enforcement as well as IP protection.
I have to say, Director Vidal, I am impressed with the range, the scope, the ambition of your outreach. Just because I'm not asking a question about inclusion and outreach, as Senators Hirono and Padilla and others have, doesn't mean I don't value it. It is a valuable part of the tireless work you're doing. The Shop Safe legislation that Senator Tillis and I are seeking to move would actually hold online platforms liable for harmful counterfeits unless they adopt a set of best practices. I recognize that's a step the USPTO can't take, and I'd welcome input or technical assistance on that. Let me just reference PTO fee diversion, something I've been passionate about for a very long time, because the PTO is funded with fees, not tax dollars. At different points over the last 25 years, more than $1 billion in user fees have been diverted to other government agencies from the PTO. I think giving the PTO rate setting authority is a key part of legislative engagement with the Congress. How important is it for you to be able to keep all of the fees that you collect? And have you given any thought to whether or not changing the fees for IPRs, for PTAB proceedings, so that they at least capture your actual costs, might also make sense as a way for you to, I mean, it seems odd to me for inventor application fees to be subsidizing, to some extent, challenges to those very patents.
Well, I appreciate the feedback on the IPR and PTAB fees. We are going through fee setting right now, both on the patent side and the trademark side. So that is something that we're looking into when it comes to those fees. In terms of how important it is for us to keep all our fees, we are not funded by U.S. taxes. So in order for us to operate, in order for us to bring down pendency, to be innovative and creative, and to stay agile, which is especially important now as we're seeing artificial intelligence in over half of our technology groups and patents, and we're seeing new scams on the trademark side of the house. We really need the ability and flexibility to be able to allocate fees and allocate our workforce so that we can keep on top of the most pertinent issues at the time.
I must say, I am struck by the reach of some of the trademark scams. My folks shared with me a scam in which a Chinese company filed 2,000 trademark applications under the name of a dead American lawyer. You've certainly warned about scammers calling trademark holders, impersonating examiners, demanding payment not to cancel registrations. What more could we do together to identify fraud and make the trademark registry cleaner, better, more accessible, but also more protective for legitimate rights holders?
I'm happy to take that back to my team and talk to you. I know that every time we see something, we make changes. So in view of the latest scam, which is, as you mentioned, is people impersonating the USPTO and watching when trademarks are filed and immediately reaching out and say, if you want to get your trademark, you have to pay us money. We are now putting a cover letter on trademarks as well. I don't believe it's gone out yet, but we've crafted one that lets people know that we are not going to ever call them and ask for fees. And so we are always, it's a little bit like whack-a-mole. We're always trying to figure out what's the best response and how quickly can we put it into effect. And then also, as you recognize, we communicate with our stakeholders directly and try and get the message out. But it's just really important that we inform our stakeholders and then take any action we can. We've taken a lot of actions with regard to sanctions, with regard to sending lawyers to our Office of Employment, Enrollment and Discipline, and we're doing everything we can at every stage, and we're investigating all of these types of activities to make sure we stay on top of it. But to the extent that we might be able to work together on that, I would love to talk to the experts in my office and see what great ideas they may have.
Thank you. This is my last question. Our first subcommittee hearing was on foreign competitive threats to innovation, and it highlighted China's abusive practices with a particular focus on standard essential patents, or SEPs. Given that ongoing challenge, that abuse, I've been following with genuine concern recent proposed regulations by the European Union for what would essentially be an SEP rate court. That regulation, I'm concerned, validates China's practices that have also harmed U.S. patent holders. And I have shared those concerns with Secretary Raimondo during an appropriations hearing, and she agreed the proposal is problematic. What steps has the USPTO taken to communicate concern to our European colleagues, and what steps do you think the administration can and should take to guard against restrictions on ICP licensing in the EU and globally?
As I mentioned in my opening remarks, that's one of the things that I'm keenly focused on is standards, because I think it's critical to our economy. I will say that when we withdrew the 2019 policy statement around SEPs with NIST and DOJ, it was because we see standards as an international issue, that individual countries weighing in these ways could be extremely problematic. So what we've done when it comes to the EU directorate is I've met with the EU IPO in Geneva just a week and a half ago. I've also spoken to other stakeholders in Europe about this. We also are issuing soon an FR notice, a Federal Register notice, to seek feedback from U.S. stakeholders on international SEP policy so that we can inform an all-of-government approach. That's going to be not just the USPTO. I'm doing that with NIST, our Standards and Technology Group, and ITA, our international group within Commerce, so that we can get an all-of-government approach to this that's data-driven by feedback.
Well, Director Vidal, I appreciate your participation today.